matter 57004, compulsory discipline involving Ronald Eugene Reynolds. Ms. Stevens, you may proceed.
May it please the board, counsel. This is a compulsory discipline case based on respondent's convictions for 1 count of barratry and 4 counts of barratry ill-obtained employment. The petition for compulsory discipline was filed with this board on December 2nd of 2015. The first amended petition for compulsory discipline was filed with the board on in February of 2016. Respondent was personally served with the first amended petition by Michelle Solomon, a process server, on February 25th of 2016. Proof of service has been on file since April 13th of 2016, and respondent filed an answer, I believe it was yesterday. On or about July 31st of 2015, respondent was charged by 5 informations with barratry. On or about November 24th of 2015, a trial judgment of conviction by jury was entered in case number 15-307888, styled the State of Texas v. Ronald Eugene Reynolds, in County Court at Law 4 of Montgomery County, Texas, wherein respondent was found guilty of barratry and was sentenced to 365 days in the Montgomery County Jail, ordered to pay a $4,000 fine and $292 in court costs. Additionally, on that same date, there were 4 trial judgments of conviction by jury entered in cause numbers 15-307889, 15-307890, 15-307891, and 15-307892. In all 4 of those judgments, respondent was found guilty of barratry, ill-obtained employment, and was sentenced to 365 days in the Montgomery County Jail, all to run concurrently with the first judgment, 15-307888, ordered to pay a $4,000 fine and $222 in court costs. Petitioner's Exhibits 1 through 5 are certified copies of the 5 different informations charging Mr. Reynolds. And may I have a copy for counsel? 1 through 5 are the informations, and 6 through 10 are the certified copies of the trial judgments of conviction by jury. Exhibit number 11 is the affidavit of myself, the original affidavit, attesting to the fact that the respondent is the same person as the person identified as the defendant in the underlying criminal cases. And Exhibit 12 is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 6th of 2016, which indicates that respondent is licensed and authorized to practice law in Texas. I'd offer petitioners 1 through 12 at this time.
You have no objection?
Admitted.
May I please?
Thank you.
Respondent filed notices of appeal to the Court of Appeals for the 9th District of Texas on December 10th of 2015. We are here requesting that this board suspend Mr. Reynolds pending the outcome of his criminal appeal. I would go ahead and address Mr. Reynolds' contention that the board should not suspend him during the pendency of his criminal appeal. And this might sound familiar, but I have 5 points that I'd like to address for why this board should interpret the Texas Rules of Disciplinary Procedure Section 8 to, in harmony interpret BODA's internal procedural rules in harmony with the Texas Rules of Disciplinary Procedure, specifically Section 8, that addresses compulsory discipline. And it's the Commission's position that that's the only reasonable interpretation of those 2 sets of rules. The Texas Rules of Disciplinary Procedure provides the primary source of authority for compulsory discipline in Texas and for this board to operate within. BODA's internal procedural rules should be interpreted to assist those rules rather than to contradict the rules. That's my first point. Second point is as the Texas Supreme Court noted in the Ament case, that the purpose advanced in favor of compulsory discipline is the protection of the public from attorneys who are under disability of criminal censure. Mr. Reynolds is currently under 5 different criminal judgments, and he is under criminal censure, and he should be suspended during the pendency of the appeal. The third point is that Prior to the change in BODA's internal procedural rules that went into effect in February of 2015, it was well settled that an attorney who had been convicted of certain types of crime, intentional crimes, should be suspended during the pendency of their criminal appeal. I'll point out for the board 2 different cases. The State Bar of Texas v. Heard. The statute that was in effect at the time to do with compulsory discipline was substantially the same as far as whether an attorney should be suspended during his appeal, as substantially the same as our current statute. In Heard, the district court who heard the compulsory case decided against the State Bar when the State Bar moved to have the attorney suspended during the pendency of his appeal. The State Bar filed a writ of mandamus with the Supreme Court. The Supreme Court wrote an opinion in that case and held that the district court did not have the discretion not to suspend the attorney in that case, that they ruled that the court had a mandatory duty to suspend during the appeal. And then more recently, the Mercier case, the Supreme Court noted in its opening sentence that upon conviction of certain crimes, an attorney's license must be suspended pending appeal. Later on in that opinion, the court noted again, pending his criminal appeal, the Board of Disciplinary Appeals suspended Mercier's license to practice law as required by Rule 8.04. And that Rule 8.04 is part of the Texas Rules of Disciplinary Procedure. The fourth point, and I think this is really important, is that the respondent that is given a fully probated suspension has the incentive to delay an appeal as long as possible to potentially not have to be suspended at all and to go before this board, and this board would only have the discretion at that point once it's if the probation were over by the time the appeal was final. This board would only be able to either disbar or dismiss. There would be no discretion to suspend because, as we know, the suspension can only last for the duration of the actual probation. And the fifth point is, this is really, really applicable in this case. If you read respondent's answer, he says he wants to show you various facts in order to ask you to not suspend him during the appeal. The facts that he wants to show you, if you read through them, are a collateral attack on the judgments in this case. He talks about what the jury did, that the state of Texas wasn't held to their burden. Those are collateral attacks on the judgments that are completely inappropriate for consideration by this board. He's trying to get the collaterally attack the judgment, and then I assume he would have Mr. Reynolds come testify, and that would be getting into the actual facts of the underlying criminal case, which again is inappropriate for this board to consider at all at this point. That's more properly considered when the conviction is final. In addition to that, the Texas Rules of Disciplinary Procedure 8.01 provides the mechanism where you can consider the full facts, and that is in a standard disciplinary case, not a compulsory discipline case. Those are my 5 points on why this board should use the interpretation that I'm arguing for and suspend Mr. Reynolds during the pendency of his appeal. If this board decides to use the interpretation that Mr. Wagnon has put forth, you should consider not suspending an attorney during the pendency of their appeal under very, very rare circumstances. The public policy reason for an attorney to be suspended during their appeal is that an attorney is under criminal censure should not be practicing law in Texas. So you should use that potential discretion very, very carefully and only do so in very limited cases. And I submit that this case is not the case for several reasons. The board should look at prior disciplinary history, and then the conviction itself is for barratry. Barratry is listed in 1.06, I think it's AA, as a serious crime. It's listed by name. And so the commission encourages the board to suspend Mr. Reynolds' license to practice law during the pendency of the appeal, regardless of which way you decide on the legal argument about how to interpret the Texas Disciplinary Procedural Rules and BODA's internal operating rules. Thank you.
Thank you.
I got one quick question. What's the status of his authorization to practice law?
It's my understanding that the appeal bond prohibits Mr. Reynolds from practicing law. I'm unsure if there's been anything changing that status. So I'd defer to
That's your
defense counsel.
understanding. Thank you.
Thank you very much.
Thank you.
Mr. Wagnon? And Mr. Wagnon, perhaps you can help us out on Mr. Johnson's question.
The answer to that question is originally the bond condition to be out on bond pending appeal did require that he surrender his law license or agree to a suspension. It's my understanding that issue is also on appeal as well, as part of it, saying that, you know, a court, as it's been argued here, courts have no authority to determine what the state bar rules mandate or licensing unless it's a disciplinary
Is the
suit.
trial court order stayed in some fashion?
Order of the state?
Is it stayed?
Yes, the imposition of the sentence is stayed currently.
But the bond
Right.
is conditioned on your client not practicing law.
I believe that's correct.
And is it the view here that we should collaterally attack that condition of his appeal bond?
No, I'm not asking for that. And I'm
Bottom
gonna,
line, is he practicing law right now?
yeah, I'm going to make this a lot easier on you guys. Is I'm going to make a few brief remarks, and I'm co-counsel with Mr. Reynolds on this, and I'm going to let him address a lot of those. It's probably a little unusual, but
That's
he
fine.
wants to address the panel, and he knows better than I do because I was not trial counsel.
Fair enough, go ahead.
All right. The rules do provide that a serious crime is specifically identified as barratry. If you refer to the penal code, it specifically says that a final conviction of felony barratry is a serious crime for all purposes and acts, specifically including the state bar rules and the Texas Rules of Disciplinary Procedure, and that's Penal Code Section 38.12, subparagraph I. Mr. Reynolds was not convicted of felony barratry. He was acquitted of felony barratry. Then a mistrial was declared and they retried him on the misdemeanor counts. We're not disputing the state of current affairs. Mr. Reynolds stands convicted of those 5 misdemeanor counts. Those 5 misdemeanor counts are on appeal. He was charged, he was tried and convicted after he was acquitted of the felony. There's also a pending disciplinary suit in Harris County for these same facts, okay? And I do represent him in that particular case. But I think we realize that we're asking for something exceptional that normally would be considered on the back end after an appeal. But one of the defenses and one of the things that's come up with Mr. Reynolds is the whole thing stinks. I mean, did he do something wrong? Well, the jury made a decision that he did. But there are other attorneys who had 500 dirty files that pled guilty to 1 count of misuse of a police report, and they don't stand before you today. None of those parties have been brought forward. There were 8 attorneys arrested, or 7, and none of them stand before you guys today. And so we just feel like the whole facts and circumstances at least warrant us standing in front of you and explaining some things. I really want to turn it over to Mr. Reynolds because he can answer your questions way better than I can.
Has any disciplinary action been filed against these other 8 attorneys?
Not that we've been able to determine. There may be some evidentiary things going on. Obviously, those are not public record.
All right, thank you.
All right.
Good afternoon. My name is Ron Reynolds, and I appreciate the opportunity to speak before this panel today. This is a very unusual matter, and without going into all of the details, we have the record, and the facts of this particular matter are that I was charged with misdemeanor solicitation of professional employment, meaning that I personally or knowingly permitted another person to solicit cases, accident cases, within 31 days of an accident. As my counsel stated, I was tried on the felony barratry, which is the statute that is listed in terms of automatically, being disbarred while you have an appeal. I was acquitted of felony barratry in Montgomery County. When this matter came forward, and the reason why it's on appeal now is because every single witness in the trial testified that I had no knowledge that solicitation was going on. What my counsel tried to bring to this panel's attention is that the other attorneys, they all pled to a misdemeanor of a lesser included offense from barratry. They all pled. I was the only person that took the case to trial. And the reason why I took the case to trial was because, unlike the other attorneys, the person that was doing the solicitation was a former employee of our law firm. And
I have to object, this is a collateral attack of the judgment. In addition to that, if we're gonna have testimony, I'd like to be able to cross-examine and have him sworn in.
Well, I really want to avoid
Okay,
that.
but I'll move past that.
Thank you.
The reason why I think that this case is unique is because of what we call selective prosecution. I am a member of the Texas legislature. I'm a state representative. I happen to be the only person in this case that has been pretty much singled out. And anyone who's looking at the facts can see that it was not based upon any of the evidence, but because of my status as an elected official. And I do believe elected officials should be held to a higher standard. But I don't believe elected officials should be, their rights, their constitutional rights should be trampled upon simply because they're an elected official. And
Mr. Reynolds?
Yes.
Let me stop you right there. I understand what you're saying, and I appreciate that. But isn't this case also a little bit unique because you've been suspended 8 prior times?
I'm not sure what you mean by that.
You've been suspended from the bar for 8 times before you stood here today.
Well,
And even though there were minor violations, you don't seem to be able to abide by the state bar rules. You don't pay your occupation tax, you don't keep up with your CLE, you don't pay your state bar dues on time. I mean, don't you think that's unusual?
well, I think those, like you said, those were those minor circumstances, and certainly I haven't repeated that, but yes.
It's been going on since 2003. 2003 through 2014, you've been suspended 8 times for breaking the state bar rules with regard to your profession, and now you've been convicted of a crime that it directly involves your practice of law, right?
Yeah, that is correct. And since we can't talk about, the evidence in this case, I would just submit to you that none of the other matters were involved in anything alleged criminal conduct.
Okay, I agree with that.
Go ahead.
And so this particular matter, and to address a question that was asked about the appeal, it is currently on appeal, and the condition of the bond is one of the things that one of my colleagues, Representative Harold Dutton, is challenging because in the nature of what he calls that the judge didn't have the discretion to set that as one of the conditions of the bond. So that is on appeal as well, and that is one of the first things that should be addressed from the appellate court.
Are you currently practicing?
No, I'm not.
Without going into, or maybe I think you may have waived it at this point, but attorney-client privilege, were you offered this same deal that these other guys took?
Yes.
Okay, and you decided to go to trial?
Yes, correct, because I was innocent. I did decide not to accept any plea.
When was the felony case tried?
That was tried the previous year to 12 jurors, and I was acquitted of the felony barratry.
How many counts?
It was the same 5 counts.
Five.
They just mirrored. I was acquitted of the same 5 charges that I was eventually acquitted of, and I was acquitted of 5 felony counts of barratry. And then I was retried because there was a misdemeanor on the acquittal. It was an acquittal of the misdemeanor, and then I was retried and then found guilty of misdemeanor solicitation of professional employment. So the barratry, they couldn't retry me on the felony barratry because of double jeopardy, but I was tried for misdemeanor solicitation of professional employment.
Did you allege double jeopardy on the misdemeanor allegation?
No, because I wanted to have my day in court. I wanted to tell my story, and so I did not.
Okay.
Mr. Echeverria?
So the bond condition that you not practice law is still in effect, there's no stay?
Everything is stayed, but as a condition of the appeal, until that is resolved at the appellate court, the judge's ruling on the bond is in effect.
So if that condition was violated, would you have to go to jail at that point immediately?
Yes.
So aren't you asking us to do something that would be contrary to your appeal bond?
No, because the appeal bond simply states that I won't practice law. It doesn't state that my law license, I won't be able, it doesn't state that my law license will be in jeopardy or I'll be disbarred. It just simply states that I will not practice law. The former Judge Morris Overstreet, who was there and testified that was unconstitutional. And he's one of the witnesses for the appeal.
If this board did suspend you pending the outcome of the appeal, it sounds like to me there would be no change in your status in terms of whether you practice law or not. Is that correct?
That would be correct, but I'll just add one caveat, is that the conditions of the appeal of the bond was that I had to be gainfully employed, which I am gainfully employed from the state of Texas as a state representative. The unfortunate part about it is that it's caused extreme financial hardship because I'm not able to practice law. And one of the things that the appellate attorneys are saying is that they believe that the Court of Appeals is going to mandamus the judge on that particular condition.
What specific relief are you asking of us?
I'm asking that this body, one of the things that my counsel alluded to is that there's a pending action in Harris County for this particular matter. I've been trying to get my day in court. The bar postponed it several times. We wanted to present the evidence, and the bar moved for continuances every time we were moving forward for trial. And so they had 2 continuances. We wanted to present the evidence before the court because we believe that there's no evidence that I knowingly permitted someone to solicit cases on my behalf. And therefore, what I'm asking for this body is to not make any ruling until the Court of Appeals decides on the pending misdemeanor convictions.
But the pending disciplinary matter would require the state to prove again what a jury's already convicted you of. Is that correct?
Yes.
And here, they're going off of the conviction only. Do you understand that?
Right. They're going off the conviction only. But as counsel stated, if you look at the rules only talk us about felony barratry. And I was acquitted of felony barratry. It doesn't talk about any misdemeanor matter. And all the other attorneys, they pled to the misdemeanor, and the bar did not move for any compulsory action against them.
Just out of curiosity, you're state representative in Fort Bend County, right?
Yes, Your Honor. Yes, that's correct.
And you got tried for the criminal actions in Montgomery County.
That's correct.
Conroe.
Conroe, that's correct.
And now you've got disciplinary action in Harris County?
Well, the bar just brought the matter in Harris County. They chose the venue.
Where were these cases that you were handling that got solicited?
They were solicited, from what we know, they were solicited from Montgomery County.
And were you attorney of record in Montgomery County?
No. The person that was doing the soliciting, the gentleman by the name of Robert Valdez, he was doing the solicitation from Montgomery County. The accident cases were people who were involved in accidents from Harris County.
Okay, now I understand.
Anybody else have any questions, Mr. Mills?
Did you testify in the felony case?
No, I testified in the misdemeanor case.
You did testify in the misdemeanor case. Thank you.
Any other questions? Thank you very much, Mr. Reynolds.
Can I address Mr. Taylor's question?
You may.
15 seconds. You asked whether he was offered that same deal. He was offered a reduced misdemeanor charge, but he had to give up his house seat as a condition. So I just wanted to make that clear to you.
I have a brief response.
I'm sorry?
I have a brief response.
Very brief, go ahead.
Just point out for the board that 106AA of the Texas Rules of Disciplinary Procedure defines serious crime. It says serious crime, in quotation marks, means barratry. It doesn't say felony barratry, it doesn't say misdemeanor barratry, it just says barratry. And that's the rule under which we seek this compulsory discipline. The allegation that there's been some sort of selective prosecution of Mr. Reynolds and what has or has not happened to other attorneys in the state is really a collateral attack of his judgments and is not appropriate to be considered by this board at this time. He mentioned the Houston disciplinary case that has the same factual basis. That is perfectly acceptable and in fact called for, or at least allowed by 801 of the Texas Rules of Disciplinary Procedure that says that they are not mutually exclusive. You can come under a compulsory discipline case as well as a fact case. And then the last thing I have are two additional exhibits, Exhibit 13 and Exhibit 14. They are certified copies of two disciplinary judgments against Mr. Reynolds. I offer those at this time.
Are they part of what was being asked earlier or in addition to what was being asked by?
I believe what Ms. Kinzer was referencing is the details in the Blake Hawthorne certificate indicating when Mr. Reynolds has been administratively suspended. These are in addition to that. These are disciplinary suspensions.
Go ahead.
No objection.
All right, thank you. The exhibits will be admitted, no objection having been made.
And in those two judgments, Mr. Reynolds was actively suspended for a portion of each of those judgments, one for a year. The active portion was for a year in one of the judgments, and the active portion in the other was for 3 months. There are a number of rules involved in both, including 804A3, which is dishonesty, fraud, deceit, and misrepresentation, at least in one of those judgments.
Thank you very much.
Thank you.
We will take the matter under advisement, advise you of our decision. That would conclude our docket for